Hello and welcome to Privacy by Design, building solutions for CPNI compliance. We are glad you're here. I am here with two attorneys from the COMMLAW Group, which I'll introduce. This webinar is brought to you by Marashlian and Donahue, a new kind of law firm, and ECG, an engineering firm where your voice really matters. So today I am here with Linda and Diana. I'm Mark Lindsey. I am the VP of Engineering and a senior member of technical staff at ECG. I've been designing voice and data networks at ECG for a couple of decades. We primarily work with carriers and large enterprise in our practice. I'm joined today by Linda McReynolds, who is with counsel at Marashlian and Donahue. She advises clients on a wide range of privacy, consumer protection, and data security matters, including compliance with FCC, CPNI rules, and state privacy and data security laws. Welcome, Linda. And I'm also joined by Diana Bikbaeva, a senior attorney at Marashlian and Donahue as well. She advises technology, telecom, and digital media companies on corporate governance and transactions, privacy, telemarketing, and robocall mitigation matters. So welcome, Diana.
Thank you, Mark.
So before we jump right in, let me ask you guys, how did you get started in this privacy area originally?
I think I'll start. I've been a long-time telecommunications regulatory attorney, and we started getting questions from our clients about, why am I being asked to sign a HIPAA business associate agreement? What is this? And so I started getting questions coming up, particularly in our space, our client space, that tends to be telecom vendors to companies that collect a lot of data. So I just became interested and curious and started answering those questions, and it's grown from there.
Thank you, Linda. As for me, I've always been fascinated by telecom and technology in general, because I'm an avid user and beneficiary of all of that. And when AI started really getting prevalent, I got very interested in that. And one of the important legal aspects of AI law is privacy. So my interest in privacy was largely caused by my fascination by AI and then the desire to learn all the aspects that are important. So that is how I got into privacy law.
That's great. Yeah, thanks for sharing that. That's interesting background, how we all come to it from different places. So Linda, can you get us started by telling us about the problem we're trying to solve?
Yes, I think the problem really stems from, as Diana was just referring to, there are so many new technologies. Threat actors are really nimble. And so from a level of data security, which we all know data security and privacy are not the same thing. And so there's really the reason we are addressing privacy by design, which is a term of art, as you know, in the privacy world, that includes principles such as integrating privacy into the design of networks, into the infrastructure, having a user-centric, user-focused approach, and being proactive instead of reactive. So this idea of being proactive and trying to get ahead of threat actors who have been finding ways to exploit vulnerabilities, it's a problem that we all share. And more the FCC is trying to address this by rule. But the rules change very, very slowly, whereas threat actors are able to adapt, and they're really agile and nimble, and they can get around it. So in today's presentation, we're really going to break this down into 3 points, looking at the specific vulnerabilities that the telecom industry is addressing now, and how. So Diana will talk about really what is happening in kind of detail. Next, we will go over recent rule changes that the FCC has come out with that are trying to address this, but also realizing that the FCC can't embed everything in a rule. They need to rely on carriers at the design level to respond and be agile and flexible and stay up to date. So the rules are meant to be kind of future looking, but time will tell whether they're achieving that goal.
So, can you guys tell us, some of the important background facts that we all need to know here?
Absolutely, Mark. According to Communications Fraud Control Association's Worldwide Global Telecom Industry Survey, telecommunications fraud continues to impact the global community, companies globally, with a 12% increase in fraud loss reported in 2023. As compared to 2021. And this equates to an estimated almost $40 billion dollars lost in 2023, which represents almost 2.5% of telecommunications revenues. So this is a huge problem for the industry. And the survey revealed that top fraud methods were subscription fraud, so like credit mule, PBX fraud, service equipment abuse, and account takeover, which in general, all these methods account for 51% of all the fraud issues. And the Communications Fraud Control Association also reported that telecommunication account manipulation is growing in popularity compared to technological methods of hacking accounts and the like, which means that the rise of social engineering attacks and it also means that those attacks are becoming technology agnostic. So all of the voice service providers should be on the lookout for potential fraud and take measures to safeguard the information of their customers. And an example of account takeover fraud that has attracted the FCC's intense attention recently is SIM fraud, which according to FBI accounts to $72 million lost to this kind of fraud. And threat actors are trying to gain control of consumers' mobile phone accounts, and that can wreak havoc on people's financial and digital lives without the fraudsters taking hold of the customer's device. So you all obviously know that mobile phones and mobile phones are tied to telephone numbers are tied to a number of authentication methods in different banking apps and other important applications containing sensitive consumer data. So these types of fraud are very dangerous for society. Let's talk a little bit about SIM fraud in general, because it will give you an idea of the different types of account takeover fraud. In the first type of the scheme, in SIM swap, a threat actor tries to convince a victim's provider to transfer the victim's mobile service and telephone number from the victim's cell phone to a phone in the threat actor's possession. And this type of fraud involves an account being fraudulently transferred or swapped from a device associated with the one SIM to a device associated with a different SIM. And in the second type of scheme, in the port-out fraud, the threat actor tries to pose as the victim and contacts the wireless provider of the victim, and simultaneously opens an account with a wireless provider with a different, a wireless account with a different provider. And then the threat actor arranges for the victim's phone number to be transferred to the account with the new wireless provider controlled by the threat actor. And consumers use phone numbers to authenticate their identities across a variety of accounts. SIM fraudsters are trying to gain control over those accounts, over the information that is contained there, or they're trying to effectuate different actions such as money transfers, etc., to targeting the information and the funds of the victims of those fraud activities. And
Well, it's really fascinating that the use of SMS as a multi-factor authentication has really been a trigger for so much of the bad actor activity around this particular space. Like, it's really motivating it. But I think you made a key point that, like, well, the SIM swap is a particular instance. It's a special instance of a particular thing. So the I wanted to cover some account takeover examples kind of beyond that. So there's the SIM change that you talked about, tricking. And I don't really mention the port out. Port out's kind of another category there that you identified. But the SIM change where you're tricking a regulated wireless provider, so a CMRS provider. So this is not necessarily just somebody who has a mobile app that works on wireless phone, but actually a CMRS provider, to trick them to switch over to a new SIM, to a new ICC ID, or in some way kind of get that switched over. So that's one category. But equally concerning are these other categories that affect other technology types. So SIM trunking change. So where you have SIM trunking, and in many cases, the authentication is done based on IP address in effect. And so contacting, saying, hey, I'm a new employee of XYZ Telecom or ABC Enterprise, and I need to switch my SIM trunking to route in a different way. You could potentially see cases where that would be used to perpetrate pretty serious takeovers of the service provider or of an enterprise. Another one that's kind of under the same heading would be UCaaS fraud, and this is something, of course, that the UC industry has been fighting since at least 2009. It's been a pretty big deal, where attackers are frequently trying to gain access to users' accounts by SIP registration fraud, or potentially by calling in and saying, hey, my old phone died. I've got a new Yealink MAC address for you. I need to switch that out, and providing a new MAC address. That was basically a different technology, same fraudulent action, moving that over. And then now you can receive those calls from the bank to say, yes, I actually do have, this is the code that the bank called me to get. So if you can take over somebody's VoIP account. And then user login fraud. We've got a case of that coming up where you guys are going to talk about, where you're changing the login credentials on an app-based service in order to get access through, for example, a password reset process. Any of those are functionally equivalent to the SIM change, and they each bring different categories. And I think it's important for the product designers and engineers in the audience to think about the fact that just because you move away and you convince your customers not to use SMS, if you provide a way to do voice dial out, use voice dial out as an authentication method, or hey, I'm going to call you back at your telephone number that you've got listed as a backup number. Well, that's the reason we have to provide protection for all of the different technologies that are subject to this kind of attack. So can you talk to us about some of these examples of these methods that are have been covered in that? There was a DHS study that you referred to on this issue.
Certainly. It is important to understand the types of threats and the types of technology that the criminals are using to build effective measures to safeguard CPNI information. And one of the biggest methods is social engineering, when the fraudsters are trying to convince customer care representatives to port the account from the owner to the fraudster, and they use phishing for that, MFA fatigue, or impersonation. And with the advent of AI, generative AI, they can use that to impersonate either the customer or the customer care representative's manager, with more convincingly. So they can use deep fakes, so AI generated video or audio that imitates another person more convincingly. Fraudsters also use fraudulent emergency disclosure requests, trying to impersonate law enforcement to obtain sensitive customer information. So it's important to see where those requests are coming from, and to have the mechanisms in place to verify that this is a real emergency disclosure request prior to responding to it. Criminals also purchase login credentials on the deep web, or they somehow else use either leaked databases or something else to obtain credentials either of the customer or of the employees of the telecommunications company. And finally, fraudsters exploit software vulnerabilities.
Yeah, I think it's an interesting point you make about these fraudulent emergency disclosure requests, because some service providers experience this. But if you're large enough, you're going to have cases where there's a bomb threat that's called in, and local law enforcement has special rights to request information, and it's a different process than you would normally take from a regular. It's not a subpoena or a court order in the same mechanisms are just not used there. And you're saying that basically the service providers really need to authenticate that, confirm that that's actually legitimate, even though you've been told that there's a potential for a bomb threat or some other kind of imminent danger. That's where attackers are going, and they're directly going to service providers with those, because those are the ones with the information. That's fascinating and really serious. So tell us about the risk of noncompliance.
Absolutely. First, there is a risk of FCC enforcement in case of CPNI breaches or other non-compliance with the CPNI rules and other Section 222 of the Communications Act requirements. So the FCC is aggressively investigating potential violations of the Communications Act and the CPNI rules adopted under this act. And the FCC will infer that a carrier did not take reasonable steps to protect CPNI information if there is an event of a pretexter gaining unauthorized access to this information. So the carrier will then have to have the burden of proving the reasonableness of its protective measures. And the FCC has indicated that it will sanction or impose forfeitures for any violation of the rules. It is expected that the FCC will boost its enforcement activity this year, especially after the new rules that Linda will talk about go into force and before the presidential elections. The FCC also launched the Data Privacy Task Force in 2023, showing that the FCC takes privacy matters very seriously. A monetary forfeiture is a risk under FCC enforcement, and it can reach $237,268 for each day of a continuing violation, up to over $2 million for a single act or failure to act. And for example, in CPNI breach cases, each unique customer logging in violation of the CPNI authentication rules is a separate apparent violation. In case of FCC enforcement, carriers will be subjected to additional public reporting obligations, which can ruin their reputation with the customers and is not something to look forward to. Then there's also a risk of civil litigation or arbitration when customers sue the telecommunications companies, and T-Mobile, for example, agreed to settle a class action suit over the 2021 data breach for millions of customers, agreeing to pay $350 million to fund those claims. So it's a lot of money. And finally, non-compliance with privacy laws can potentially deter investors or buyers or significantly drive the purchase price down. So it is something that investors and buyers look into.
Wow, there are a lot of risks there. There's a lot of dollar signs that you just went over. So there's this one case I'd like you to cover with Q-Link, which is really fascinating because this is basically not a CMRS provider. So this is not an official cellular company. This is an over-the-top VoIP provider. Tell us about this one.
Absolutely. So as you may be familiar with this case. Last year, Q-Link and Hello Mobile had to pay $20 million in FCC forfeiture. And This happened because they used customers' phone numbers to authenticate them. So anybody entering a mobile phone number could log into the customer's account on their app and in the browser as well. And the forgotten password authentication also involved readily available biographical information, which is prohibited under the current CPNI rules. So the $20 million forfeiture was calculated as the base fine of $40,000 multiplied by 500 violations within the relevant time period. And this is a screenshot obtained by a journalist from a by a journalist to show the interface that prompted the user to enter their phone number to get authenticated.
That's interesting. So just the password reset mechanism, which honestly, it sounds like a very ordinary one that might have been chosen by, the software developers, ends up creating really major vulnerability here. So Linda, I know there are some rule changes, some recent rule changes, and I'd like you to tell us about what's happening there. Looks like Linda may have been dropped off the webinar. Well, when she joins back, we can cover this. Diana, would you like to talk about any of these rule changes?
Sure. So recently, the FCC strengthened its protections against unauthorized access, use, or disclosure of customer data, which also expanded the breach notification rules and added restrictions along with reliance on carriers to design certain secure customer authentication methods and adapt them over time. And the FCC proposed to further strengthen and expand the scope of CPNI protections. Let's see. So telecommunications carriers have an obligation to protect the privacy and security of information about their customers, to which they have access as a result of their unique position as network operators and as the gatekeeper to their customers' access to the network. And the Communications Act specifically limits the manner and circumstances under which a carrier may disclose certain information that it has received or obtained by virtue of its provision of telecommunications service, which is the CPNI information. And the CPNI includes services subscribed to, such as caller ID, call forwarding, call waiting, numbers dialed, information or invoices. It can also include network design, such as the IP addresses, routers, switches, and other infrastructure used to provide the voice service. Importantly, it can include geolocation. And breach notification rules now expanded the scope of protected consumer information beyond just CPNI to any information that can be used to distinguish or trace the individual, either alone or when combined with other information. And CPNI is a subset of personally identifiable information.
So I know there was a change in the rules, and we'll go over kind of what the current rules are versus the adopted rules that are going into force this year. But the geolocation is a really interesting point, because this is actually for voice engineering in the US, this is becoming a more prominent factor across VoIP, and of course, wireless providers. VoIP providers have to work really hard now to get better and better location information, latitude, longitude, and elevation coordinates for 911 services. So we are, that's a new thing that's come in the past few years with the Ray-Bombs Act and Kerry's Law that has radically changed the relationship between VoIP providers and the locations of their users. We have to know where they are. We have to be able to sense when they move and things like that. And so that kind of information, that sensing information about the location or either the registered location or the sensed, like detected location, is part of that. It's interesting that they specifically called that called that out. Let's look at the changes in the rules between the current rules and the adopted rules. Is there anything you'd like to highlight from this change?
Sure. Compared to the current rules, under the rules that go into effect in 2024, the carrier would have to notify the FCC as well as the Secret Service and the FBI about any breach that might have happened within 7 days of the breach. Then unlike the current rules, which necessitate that the carrier must wait 7 days before notifying the customers or the public, under the new rules, they would need to make the immediate individual notification for breaches affecting 500 or more customers, or that pose a risk of customer harm. And this must be done no later than 7 days after the breach. So this is a significant change. Finally, the reporting requirement where a carrier reasonably determined that no harm to customers is reasonably to occur, or whether breach only involves encrypted data and the encryption key was not compromised, is eliminated. And instead of individual ongoing reports, carriers may submit breaches affecting fewer than 500 customers, or where harm is unlikely, in annual summaries, which reduces the burden on the carriers. Finally, the definition of breach has changed because previously it only involved intentional access to, use, or disclosure of CPNI. But under the new rules that are going into force, the breach includes inadvertent access, use, or disclosure, but does not include a good faith acquisition of CPNI and other covered data. As I said, personally identifiable data about the customer. If that acquisition was done by an employee or an agent of a telecommunications carrier, where such information is not used improperly or further disclosed. So this also reduces the stress on the carriers.
Great. We got Linda rejoined by telephone. So, Linda, we'd like you to talk about, to whom do the CPNI rules apply, if you're able to cover this.
You're on mute.
Well, maybe Diana, you can talk about this. Who these rules apply
are you
to.
able to hear me now?
Oh yeah, there you are. Great, Linda. Yes, go for it. So, whom do the
so
CPNI
sorry for
rules apply?
the difficulties. Of course, it happened, right on time, but I'm happy to be able to join.
No worries.
So, and Diana, thank you for going over the changes to the breach notification rules. The CPNI rules, which have changed over the past, 20 plus years, originally applied to telecommunications carriers. They were expanded to apply to interconnected VoIP service providers. And now there are some new rules that we're going to talk about that apply to wireless carriers in particular. So we have kind of a variety of applications of the CPNI rules depending on the type of information you're protecting, the type of account activity that a customer is requesting, and now we have some variety based on the type of services that you're providing. So across the board, most of the requirements apply to telecom carriers and VoIP service providers. We also frequently come up, as I mentioned in the beginning of the presentation, our clients are telecom carriers, but they're also vendors to these carriers and maybe creating software solutions, platforms and other things. And so it's good to understand what your customers, who are themselves directly liable under the rules, might need. Even if, so there may be a business case for developing compliant solutions, even if as a vendor, you don't strictly fall within the rule requirements. And so when we look at developing contracts for our clients, depending on where you fall, they're looking at an allocation of risks and responsibilities that balances the direct regulatory requirements with maybe features that are good to have for your clients who need to comply. We will get into this in the next couple of slides, but the FCC has been strengthening its protections around CPNI, requiring different types of authentication. They're trying to have the rules keep up with the types of pretexting that Diana talked about earlier. And there is a proposal to further expand these rules to apply to all telecom carriers.
So I know there are some specific rules that are for customer authentication, these new FCC customer authentication rules. Linda, can you tell us about these?
Yes, so the authentication rules, as you can see from this slide, there are various levels of authentication requirements now. And now with the new rules that are kind of added on to the end that are specific to wireless carriers who may be dealing with SIM swap and port out, now you have quite a variety of rules. Some are prescriptive. So for example, for most telecommunications and VoIP providers, the existing rules require that you authenticate a customer. When a customer calls in, so it's a customer initiated call, they call in, you have to authenticate that customer before you can disclose customer proprietary network information. For wireless carriers now, you have to authenticate the customer before that care agent can access CPNI. So there's an example of where the rules are really different depending on the type of service. Another difference is that there's kind of a subset of CPNI, which is considered more sensitive, and these are call detail records. So numbers dialed, when, how long the phone call was. Call detail records, again, in 2007, the FCC saw that pretexters were getting access to call detail and then using that information to commit identity theft and other things. And so this is a subset of CPNI, but it's considered highly sensitive. But under these old 2007 rules, you have to have the customer provide a password before you can release call detail over the phone. Passwords, as we're talking about, are not necessarily the most secure authentication method, but yet they remain in the rules.
Yeah, and when I hear a password, I mean, the immediate thing, if you've worked with products that are going to be used by humans, then you always have password reset, which means that there's always some backup authentication mechanism. And so it does create some complexity here to figure out, well, how do I comply with the rule? But also, how do I deal with the fact that humans forget passwords, like legitimately forget passwords, they write them down wrong, or they forget them. And so that raises challenges. I think that's the one thing I've enjoyed working with the COMMLAW Group really was having back and forth and conversations between the engineering and product team and attorneys on these kind of questions, figuring out what the details are, what can we do, and how can we make it work in a way that's good for customers and fully compliant. Let me ask you, you can move forward into the special customer authentication requirements about SIM change and port out. Can you cover that?
Yes. So, and I appreciate that you said how to, Mark, because often the conversations between attorneys and engineers are, at least the way we like to do this is not saying no, waving the flag, stopping things, but how to comply, what are options, what are workarounds. And the example you gave, a customer forgets a password, that can be a really sticky, frustrating experience for a customer. So the rules have options for how do you get them the information they need. So there's always that balance in the rules. For one thing, you want customers to be able to, looking at SIM change and port out now, there are pro-competitive reasons to make it easy for customers to switch carriers and keep their phone number, right? So we have the local number portability rules have been in place for a long time to promote competition. So carriers who are the losing carrier can't hang on to that customer by making it difficult to keep your phone number. But at the same time, as Diana explained, if someone pretends to be the customer, they can take over the account by requesting a SIM change. And so now here's yet another layer on these authentication rules that there are further restrictions around this account action now. So a customer calls in, they want to maybe have you email them an eSIM to a new email address, and this kind of thing would happen, and suddenly your actual customer's phone has gone dark. So what do you do? So the FCC has, in its rules, has restricted carriers from using certain types of information to authenticate. Already, you can't use account information or biographical, readily available biographical information. In addition to that, before you effectuate a SIM change or a port out, if you're a wireless carrier, you can't use recent payment information or call detail information. Now, right now, this only applies to wireless, but there is a further notice of proposed rulemaking, and the reply comment period is ongoing until mid-February, February 12th. They're proposing to expand these rules to all telecom providers, VoIP providers to whom these rules apply. And there's been a lot of, interesting comment, both from the wireless industry, the VoIP industry, consumer protection industry, about how do you harmonize all of these requirements in a way that, like you said, Mark, it strikes the balance and protects consumers, but also, protects the customer experience and their access to data. Part of the rules, which is not on this slide, is that the FCC continually states that they are relying on carriers to develop a secure method of authentication that's reasonably designed to confirm the customer's identity, and that they rely on carriers to keep up with and evolve over time just as threat actors evolve.
Can you touch on the Safe Connections Act and the survivor of domestic abuse scenario that's anticipated there?
Yes, and so this is a very specific but important exception to these tougher authentication requirements, where you have a group or family plan with multiple lines, and a victim or survivor of domestic violence or related abuse wants to get that line separated from the family plan. What the Safe Connections Act is a response to difficulties people who were not the account holder on an account had a lot of problems keeping their phone number and separating it from that account. So this piece of legislation is intended to make it a little easier to get a line separation. So that's the very specific request. You have a customer calling in, wanting to separate the line. Then you can use a different authentication method. So that reasonably is designed to confirm the customer's identity, but they're not ruling out all of these other methods that you can't use for other SIM changes and port outs.
Yeah, that's interesting. So we've talked a lot about the password and kind of the weaknesses of the password, and then the need for other kind of potential authentication methods. Diana, I know you've done some work to talk about specific examples. It's always helpful to get it in your head with some specific concrete examples. Tell us about what kind of authentication methods are likely to be at least worth considering or talking about.
Absolutely. So as you know, the FCC did not end up providing any specific safeguarding measures that would allow the carriers to use a certain safe harbor in their CPNI compliance efforts. So where do we take these measures from? I wanted to give you a little intro into the FCC rulemaking process to preface some of the methods that they favorably mentioned. So first, the FCC issues notices of inquiry stating its concerns about various matters, such as, for example, CPNI protection. And the FCC asks the industry which rules would make sense, and it asks what technology carriers use, what technology the criminals use, and how to make it work to counter those attacks. And then the FCC collects the comments and adopts proposed rules, seeking further comment on the proposed rules. And after it receives more comments and it processes them, it adopts final rules that go into force after some time. So, and as Linda said, there's a chance to file comments in the further notice of proposed rulemaking as to the harmonization of authentication rules across all voice service providers. So the FCC listed in its rulemaking proceedings, but not in the final rules, certain measures, and it mentioned them favorably. So, for example, a pre-established password, a one-time passcode sent via text, multi-factor authentication through SMS or voice, and then it ended up not adopting that in the final rules because it acknowledges that technology is evolving, and there should be the measures that carriers take should also evolve. And they should be reasonable and appropriate based on the type of data that they're protecting, and cost efficiency is also relevant in this reasonableness factor. The sources for inspiration for these measures can be the FCC rulemaking proceedings, such as the different comments, the FCC's comments on those comments, and different industry standards and reports, such as the USDHS Cyber Safety Review Board's review of a certain cybercrime group's practices and the measures that can be used to counter them. So moving on.
I think it's interesting, and I'm kind of glad as a product implementer that they're not locking us into this, because I mean, honestly, for a lot of situations, like a time-based one-time password or an HMAC-based one-time password, you're familiar with some of these if you've had one of those where there's a QR code that pops up, you point your phone at it and you add it to Google Authenticator or Microsoft Authenticator, and then it generates a code that changes over time. Well, that's not on this list, but that's actually considered a pretty strong tool in 2024, at least. But it didn't make the list. So I'm glad that there's flexibility that's granted. I know some of the VoIP applications use exactly those mechanisms as part of their multi-factor authentication. So it seems like there was definitely a step of wisdom there. And for those of you, the engineers, product designers on this meeting who have not done the comment filing process with the FCC, what this means, among other things, is that you can basically say what your interests are, what you think would be best. You can give advice to the FCC. Your comments, as I understand it, always become public,
Right.
And then they're available for folks. And then, but that goes into it, and the FCC staff, the team, reads what's being said, and then they incorporate that thinking into what they're doing. So if you've got an interest in this, you think you've got great ideas, you think this is good, then or you give caution, then there's a mechanism for doing that through the commenting process, and I'm sure the COMMLAW Group can help you through making that happen. So there's a kind of a hierarchy here that they give of different MFA types. They actually refer to the time-based one-time passwords. Can you walk us through this, Diana?
Sure. The DHS Cyber Safety Review Board recommends the transition from SMS and voice-based multi-factor authentication methods to the methods that are more resistant to different threat factors, such as phishing attacks and MFA fatigue, and the superior type of multi-factor authentication is phishing resistant multi-factor authentication, such as biometric information. So authentication through the fingerprint on your smartphone or some other kind of biometric data that is very hard to hack. And there are also app-based MFAs that are a little more superior to SMS or voice MFAs. But it is interesting that the FCC didn't mention those more advanced methods of multi-factor authentication in their notice of proposed rulemaking. And that shows that there may be different authorities to look at for those measures, and that the technology is evolving.
Tell us more.
There are some more methods from the Cyber Safety Review Board's report, such as allowing customers to lock their accounts to prevent SIM swaps, which is required for wireless providers. And unless we say that this is required, when talking about these measures, they are ideas, like suggestions.
Okay.
Then making strong identity verification for SIM swaps the default is a suggestion. There can be a waiting period implemented, or additional authentication methods such as taking a photo or video authentication. You can require in-person or online government-issued ID verification, and you can track the numbers of fraudulent SIM swaps by dealer or reseller to impose business costs on them, and certainly require strong passwords. 12 different characters is a good industry standard.
We are going to have some time for questions here at the end. So if you have a question for Diana or Linda, then you can send that in through the Zoom Q&A panel. I want to just touch briefly on some of the ideas that Diana and Linda have mentioned that have come out. They've emerged as goals and best practices from the industry for the measures that you might use to protect CPNI. And really, these are going to look really familiar for anybody worried and working on cybersecurity problems. So things like a zero trust architecture, which affects the way that your, all of your network security is done. Those are good ideas. And generally what I see is that service providers are adopting these technologies incrementally, using system audits where you have some organizations come in and help you identify where the vulnerabilities are. These are organizations working, for you to find those. These things do take work, applying measures to harden the technology stack. So often there are best practices for making particular technology deployments robust against the most common attacks, and often vendors provide guidelines for doing that. Requiring explicit authentication for complex transactions, monitoring unusual transactions would be kind of a flavor of that. Shortening the authentication time to require additional proof so that effectively you can't reuse an old cookie or an old authentication session. Using maybe AI or other just simple statistical tools to monitor for signs of unusual activity. That's actually required by the NIST standard that a lot of folks work under. Using layered security so that you've got different levels of access. This is kind of starting to smell a little bit like compartmentalized access control that's used within the U.S. federal government, at least. Making policies around where and when folks can bring their own device kind of into a location, or how they can attach it to a network. And I'll say one of the reasons there is because, just as an example, Android phones are a pretty major way of delivering malware into an enterprise network. And so thinking about, well, if my employees, my very bright, well-trusted employees bring in a device that's actually itself been compromised, then what's the effect on the internal security? And then training your employees using simulated attacks. So you could call this partially a tabletop exercise. What happens if? What if this was the symptom that we saw? What if this was the kind of event that was detected by the security event monitoring platform? And then working through kind of what it would take there. And this last point is really interesting, prioritizing severe unauthorized account takeover. So when you've got volume or you have high risk, you have specific types of account takeovers, then making that a priority as opposed to just another thing on the list for the security team to go investigate.
And for
So
example,
these are all really interesting. Go ahead, Diana.
there's also for your last example, if there's been an FCC or Attorney General complaint or court order, or if the customer is a military institution or a medical facility, you might want to prioritize that.
Right. Yeah, that starts to sound like the list of organizations for whom you have special monitoring on reliability. So airports probably are on that list. Nuclear facilities probably on that list. All those kind of things. So Linda, I wondered if you could help us out by basically giving us a overall view of like, what does success look like? Like, how do I know if I'm getting this right as a team?
It's a very good question, and it's an ongoing question. I think that's one of the first things I want to emphasize is that embedded in the rules, in the FCC orders, and also in just good practices, companies should be reevaluating on an ongoing basis, and at least every year. You know, if it's been 12 months and you haven't taken a good look, it's time to reevaluate whether your authentication measures and other privacy measures are really secure and keeping up with existing threats. So just while the rules don't expect perfection, they do expect you to have reasonable measures in place. And if there is a breach, and as we've talked about, what a breach means is quite a bit broader than it used to be. If there's a breach, the burden will shift to the carrier to show that they had reasonable practices. So how do you show that? That's your question. Doing ongoing monitoring, as you said before, assessing vulnerabilities on the ground. This is where engineers are the closest to the facts and they can really assess where are the vulnerabilities in our systems. A lot of risks and threats don't pertain to you, and you don't have to think about everything, but really keep good records, pay attention to what's happening, and then look at the latest best practices and guidance that are coming out either by government agencies or approved by government agencies so that you can evaluate what you have in place against these published practices to see if your safeguards are strong enough in the current threat environment.
Yeah, that's really helpful. It requires some ongoing work. And I know, Diana, there's a deadline coming up. Can you tell us about, what that's all about?
Sure. In addition to internal safeguarding requirements, all carriers, including interconnected VoIP providers, must annually certify their compliance with CPNI regulations before March 1st every year. An officer of a carrier acting as the agent of the carrier must sign under the penalty of perjury and file a CPNI compliance certification with this FCC, showing that the officer has personal knowledge that the company has established operating procedures that comply with the FCC CPNI regulations, and the carrier must provide a statement showing which operating procedures are in place to comply with the CPNI regulations. And there is a potential for forfeiture against carriers that do not file. They amounted to $20,000 in 2009, but they can go up to, as I said previously, around $200,000 for each day of a continuing violation. So it's a risk. So everybody should file, and if you need help figuring out whether you have the compliant operating procedures in place, please feel free to reach out. We can help with that. So yes.
Yeah, that's really good to know. And so I think also reaching out to you to figure out precisely which policies are in place now and for the services that we offer, I think would be a smart move for somebody who's doing this for the first time to figure out, because there are some changes and there are some specific technology specific requirements there. So I appreciate you covering that. Well, thank you very much for covering these, Diana and Linda. This was super informative. We have a few questions. I'm going to start with one, and I wanted to see if you could tell me about when a customer calls into a customer service agent, like how much permission does the customer need to give to the agent to view their data? Do they have to, can you tell us anything about that? Is there a specific protocol or some sort of explicit consent that's required for that the customer has to provide to the agent before the agent can access the data? And I think this is probably in the reference to the CMRS wireless carriers. Can you tell us any more?
Oh,
Yes, so this is where there's kind of a hierarchy of authentication. If you are not a wireless carrier, and we're talking about customers calling into customer care. So this is a phone call from a customer, and you've got your customer care agents there who need training, by the way, under the rules. They should be trained in this. But if you're not a wireless carrier, your care agents can access CPNI themselves. And then before they can disclose CPNI, say I call in and I want to know, is there a better plan? What was my usage last month? How many text messages did I send? Or whatever that may be. Before you can disclose it to the customer, you have to authenticate them. Now, how you authenticate them, this is the big question that we're wrestling with today, must be reasonable given the type of data, the type of action that the customer is requesting. If the customer wants call detail, which is a specific type of CPNI, then you have to have a heightened level of protection. So that's where you need the password, or they forgot their password. The rules have other ways that you can get that information to them. You just can't give it to them over the phone. So that's an example. I won't keep drilling down, but depending on what the customer wants, there may be a different type of authentication required.
Thanks for that. Another question is, in the case where a government agency reaches out to a carrier for CPNI, can you tell us more about how you would go about authenticating an organization that claims to be a government agency?
absolutely.
So, yeah.
Oh, sorry.
No, please go ahead.
Oh, sure. Thank you. So first of all, you can verify the email address from which the request is coming, and 95% of these requests should be coming from a .gov email address. Then you can research the law enforcement agency making the request and place a phone call with the requester's supervisor or department to verify the identity of the requester or the validity of the request itself. And make sure to use the correct phone number and not the phone number provided by the requester in that communication, because it may be fraudulent. Then it is possible to request that to ask the requester of this information to provide a government issued ID in person, or somehow else authenticate their using their ID, government issued ID. And a requester can also provide a notarized document showing that this is indeed them. And do you have any other ideas?
Oh, and I'd like to add, if this is the Stored Communications Act governs, first you want to see, is this really a government agency or a law enforcement official who's making this request? And then beyond that, there are strict rules governing what you can turn over about your customers to the government. So they have to have a lawful request, and you really need to closely evaluate. And that's a big part of our practice, is looking at these requests. Once you see that it really is coming from who they say they are, then you have to see if the paper, the document that they've come up with, is appropriate for what they're asking for, and also check the jurisdiction and check your privacy policies. So even if you see that this really is the person they say they are, there's a lot more review and evaluation that you have to go through before you divulge customer information to the government.
That's really interesting. So if one of the folks on this webinar had a question like that, would they just email you guys directly? It's 5 p.m. and I've got, the FBI is calling, or is there a better way to get kind of urgent service, or are you guys going to be able to get that to the right place?
We do indeed handle those kinds of requests regularly in our practice. So we're happy to review, and often the balance between protecting your consumer privacy and helping law enforcement is a good balance. So once you find out, assuming that it's a lawful demand, The more you understand what they need and you can narrow it down to what they need and make sure they've requested it properly, it usually benefits everyone all the way around. But you want to make sure you're not violating privacy laws when you divulge information about your subscribers.
Well, we've come to the end of our time. We actually have some other great questions. So to get the answer to the questions, one of them is about support tickets. What about when your customers contact you about support tickets? Usually there's a lot of technical network information or service usage information. So to get that answer, you're going to have to look for the email from ECG. It'll have the access to the slides and the webinar. You'll be able to watch it or share it. But it will also include some comments on those questions as well. So thanks again, Diana. Thanks again, Linda. I really appreciate your time, and I appreciate everyone who joined in today online to watch.
Thank you so much.